Shalom to everyone. My name is attorney Michael Decker, and I'm a lawyer within the law offices of Cohen Decker, Pex and Brosh. Today we wanted to discuss wills in Israel and the way to obtain an order of an implementation of a will. In Israel, there are basically four types of legitimate and accepted wills. There is a written will. There's a will that is given, typed, and signed by two witnesses. There is a will that is made before a public authority, and there is a will that is verbal. All these four wills are legitimate wills, and all these four wills can be submitted before the Registrar of Inheritance in case the person that wrote the will is deceased. In a situation like that, the presumed heir of this will can submit a request for ratification of the will within the Registrar of Inheritance in the area where the deceased lived. In order to do so, the relevant applicant must pay a fee to the Registrar of Inheritance. One fee is to open a file, and the other fee is to submit a notification within a main newspaper in Israel in order to allow for people to submit objections against the request. In addition to submitting original copy of the will and paying the relevant government fees, it is also necessary to submit an original death certificate of the deceased. If the deceased was not a resident of Israel during the time when he was deceased, then the applicant needs to prove that this deceased person had assets in Israel by the form of an extract from the land bureau in Israel, or proof that the deceased had a bank account here, and the application will be submitted in this area where the assets have existed. If the application has been submitted properly, it will receive a number, and afterwards the representative of the Attorney General can submit a notification that he has no reason to intervene in the application, which means that the Registrar of Inheritance will sign an order for the ratification of the will. The representative of the Attorney General can also say that he does want to intervene in the proceedings, in which case the application will be transferred to a family court. An additional option is that the representative on behalf of the Attorney General will say that additional information needs to be submitted in details, and in which case the applicant will need to submit additional information. This process, naturally, as you can understand, is complicated and it requires meticulousness, to be meticulous in the process, and we therefore definitely advise to hire a lawyer for these proceedings. We at the offices of Cohen Decker, Pex and Brosh will be happy to assist you through this process, and if you have any further questions, you can feel free to ask us. Thank you very much for your time.